I believe that there couldn't be a better moderator for this topic than Mallory, and we're very lucky to have her, and lucky that she, accepted to be a moderator on a topic that she knows extensively. Mallory is an international recognized advocate with more than a decade of experience litigating high-profile international arbitrations. And in interviews with Who's Who Legal, Mallory's clients and peers have described her as a clear future leader in the field of investor-state arbitration with a creative mind and unmatched knowledge of jurisprudence and oral advocacy skills that far outpace most of her peers. And this is serious.
Det är han nu. Nej, skitsamma. Jag ska lyssna på en grej här nu.
Okay, sorry for that interruption. I would implore to all the attendees to mute yourselves. And importantly, to date, Mallory has been counseling in over 40 investment treaty cases, including more than 25 at ICSID. And across these cases, she has represented not only prominent international corporations, but also approximately 8% of the world's countries, including Chile, Costa Rica, the Czech Republic, the Dominican Republic, Guatemala, Hungary, the Kyrgyz Republic, Panama, Peru, the Philippines, the Slovak Republic, South Korea, and Turkey. These cases have involved everything from transportation concessions, telecom licenses, intellectual property, and back regulation to mining, renewable energy, environmental permits, and taxations. Mallory teaches a course on investment arbitration, which I understand doubles down on advocacy, both written and oral skills, which she masters. And most importantly, if I were to say something that I've been a witness of, is she is really creative. She's really creative and puts her heart out, one, to have something cogent, structured, but also to understand where the client comes from. And most of them are sovereign clients. I believe that she well understands the logic of a sovereign state when she defends them. So with that, I would like to not yet give the floor to Mallory, but emphasize what we're doing here. And just to share with those of you who haven't been in other sessions, the World Arbitration Update has two objectives. The first objective is to decentralize international arbitration, because we believe and we know that there are rigorous counsel, arbitrators, practitioners that may not necessarily be in the main arbitration centers or in the main venues of arbitration. So we know that there are very strong counsel in Venezuela, in Latin America, in Africa, in New Zealand, in Asia, and we want to create a platform to raise their voices. It's only fair. And the second objective is to update on issues of international arbitration, both investment arbitration and commercial arbitration. Why? Say 20 years ago, or let's say 13 years ago, when I was at ICSID, it was still possible to go and read the arbitral awards that would be rendered in a year's time, because there were so few. Nowadays, it's not possible. And by the way, this really came out of a conversation with Mallory. So, and we have to create means to update the international community, either written or video or audible, that will make a contribution to our field of practice. And that is something else that we're trying to do, both in commercial arbitration and investment arbitration. And with that, I would like to give the floor to Mallory.
Thank you so much, Jose Antonio, for that overly kind introduction. And welcome on behalf of all of the panelists to our discussion on dual nationality and dominant and effective nationality in international investment arbitration. Now, as a member of the advisory board for the conference, I very much hope that this isn't the first time that you are attending one of the panels this week. But in case it is, I just wanted to begin with a brief note on the structure. We basically will have 4 different segments of our program today. We are going to begin with an initial introduction to the topic of dual nationality and dominant and effective nationality. And that piece is going to be led by Maria Lucia Casas, who is an associate at Xtrategy in Bogota and specializes in both domestic and international arbitration and public international law. After that, we're going to turn to the second segment, which is going to be a panel discussion with 3 distinguished panelists to whom I will present a series of different questions. And these panelists include Maria Isabel Pradilla Picas, who is an associate at Jones Day in Washington, D.C., and has been counsel in numerous prior investment arbitrations that involve high stakes and the ICSID and UNCITRAL rules. We also have Maria Eugenia Salazar Furiati, who is a partner at Baker and McKenzie in Caracas. She brings to the table more than 15 years of experience as counsel in international arbitrations and someone experienced in investment protection. In addition to that, she also is part of the faculty of 2 different law schools, teaching on international investment arbitration and telecommunications law. Finally, we have Baiju Vasani, who is a partner and co-head of international arbitration at Ivanyan and Partners based in London and Moscow. In addition to his 20 years of experience as counsel in international arbitrations, he also is sitting as arbitrator, and he has advised sovereign states on the negotiation and drafting of investment treaties. I'm very excited to hear what they have to say about this topic. After about 45 minutes of my questions, we are going to turn the floor over to you and invite you to ask the panelists any questions on the topic that you would like. I would just remind you, though, that the issue of dual nationality and dominant and effective nationality is very much a live one in the jurisprudence today. So it may be that the panelists will need to decline certain questions. And you should also bear in mind the typical caveat, which is that anything that the panelists are saying today is their own comment and shouldn't be attributed to their respective firms or to their respective clients. So with that, I will turn the floor over to, actually, our last segment will be the period at the end during which we all go into different breakout rooms, and we'll get to chat with you on a more individualized basis about either this topic or anything else that you would like to discuss. And with that, I will turn the floor over to Maria Lucia to give us the initial overview.
Thank you, Mallory. Well, before starting my presentation, as part of the executive team behind this incredible event, I want to say that we are truly happy to have you here in the last day of the World Arbitration Update. And I really hope that you have enjoyed it as much as I have. Well, with that being said, for me it's a great honor not only to chair this panel with these incredible professionals, but also to have the amazing opportunity to introduce to all of you, to all our participants, a very relevant topic in international investment arbitration, which is the nationality of investors. That is nothing more than a topic that lies upon the jurisdictional requirements in order to an investor to be able to bring a claim before an investment tribunal. So I want to start this introduction to the panel by leaving a crucial question that I found really important regarding this topic, and is, can a dual national bring a claim under an international investment agreement? And I can promise that this question will be answered, but I believe our panelists will do their best. So the reason also to start with this question is very simple, and this is because if an investor is not covered by the applicable agreement, the investor will not have any substantive protection under the relevant treaty. So what it is important to analyze here is who qualifies as a cover investor under the International Investment Agreement in the particular case, and if under that definition provided by the particular agreement, it could be included an investor with dual nationality. As most of you might know, whether an investor is covered or not by in a specific case, it will depend, of course, on the specific agreement and on the facts underlying the dispute. And generally speaking, under international investment law, in order to be able to qualify for protection, an investor must be, generally speaking, a national of the contracting state, different from the host state in which they are investing. And just to name you a few examples of this and of the exemplification of this general rule, we have the Turkey and Colombia bilateral investment treaty. We have also the Romania and Canada bilateral investment treaty, and also the Mauritius-Egypt BIT. And this is also the case of this general rule on the very popular and of course known by all of you of the ICSID Convention, in which in its Article 25, it lists the different jurisdictional requirements that an investor needs to fulfill in order to be able to present a claim under the ICSID Convention. Under these requirements, the ICSID Convention, it's very clear when it deals with the issue of double nationals, and it expressly established that a dual national is not allowed to submit a claim under the ICSID Convention. So I believe that the picture, of course, is very clear for all of us when we are before an ICSID arbitration, and also when we are before a bilateral investment treaty or an international agreement that clearly excludes dual nationals for bringing claims. But life is not so simple, and of course, we as lawyers love to enter into gray areas, and in this particular topic, the gray area is here, when the applicable norms does not explicitly regulate the matter of dual nationality nor prohibit it. So what happened here? For instance, there is an example of these kind of rules, and we have the UNCITRAL rules that, unlike the ICSID Convention, they are silent understanding of dual nationals. And in this scenario, we might ask ourselves another question. What should we do? What should the tribunals do when the rules, when the applicable rules are silent? So for solving this issue, what it's been common, it's that the tribunals, of course, turn into the international investment treaty applicable to the particular case, which is, of course, a lex specialis, in order to define and to try to solve which is the nationality of the investor at issue. And when dealing with this type of investment treaties, we can find two different scenarios. One, those treaties that allows claims by dual nationals against one of the countries of their nationality, including the host country, if and only if, and this is very important, the dominant and effective nationality is the one of the non-host country. And this, of course, is the case of the United States-Colombia Trade Promotion Agreement. We also have the CAFTA. And on the other hand, we have those treaties that are silenced and that do not include any permission or provision regarding dual nationality. Regarding these two types of treaties, I want to shed light on some important cases. As to the first type of treaties, which is the ones that establish the dominant and effective nationality test, we have the case of Valentine versus the Dominican Republic. This is an UNCITRAL case that is under the CAFTA, which is the treaty that we just mentioned. And in this case, of course, the treaty includes in its clauses the dominant and effective nationality test. Just to give you like a brief summary of the facts of the case, this is a case about two US nationals that invested in a real estate project in the mountains of the Dominican Republic. And a fact that is very important here is that they were not only US nationals, but they also acquired the Dominican nationality for the purposes of the investment, which is what this was very important for the rationale of the tribunal. So what the tribunal decided in this case? I mean, of course, it shed light to us with a lot of relevant rules, but I'm going to focus on what the tribunal have said about the dominant and effective test. So according to the tribunal, in order to decide about this, it decided that it had to answer two questions. The first one is, what are the relevant times in which an individual should comply with the nationality requirement? And the second one, what is the legal standard? How we determine the dominant and effective nationality? Because in the case, the treaty was silent. Although the treaty contemplates that test, the treaty does not really regulate how to solve it. So for answering those questions, the tribunal established regarding the first one, that the relevant times in order to examine the compliance with the nationality requirement were two. First, the time in which the alleged breach was committed, and second, the time of filing the claim. And as to the second question, of course, as the treaty did not prescribe specifically the factors that may be considered to solve this test, the tribunal established that the tribunal had to resort to, of course, the wording of the specific treaty, and also to explore on their customary international law. And on referring to customary international law, it also referred to the very famous ICJ case, which is the Nottingham case. And by doing so, the tribunal considered that the relevant criteria in order to determine the national effective nationality was the claimant's habitual residence, its personal connections, its economic and family center, and the acquisition, of course, of the second nationality voluntarily for the effects of the investment that was being made in the particular case. We have also another case very similar to this one. Of course, the facts were different, but the rationale behind the case, it's very similar, and it's Carrizosa versus Colombia, my home country, of course. And this was a case about three brothers that were born in Colombia. So of course they have the Colombian nationality, but they also have the US nationality because their mother is a naturalized US citizen. So in that case, the tribunal not only analyzed the critical days that we just mentioned in the case before, but also it made a huge analysis of the entire life of the Carrizosa brothers. The tribunal established that was very relevant for this to undertake an objective factual analysis rather than consider the subjective appreciations of the Carrizosa brothers on what they consider that their dominant and effective nationality to be. And now we have to move to the second type of cases that we have, that is those cases that dealt with treaties that were silent in determining the nationality of the investors. And here we have three different cases. I would love to delve into cases, but since we don't have much time, I will just mention the cases for the purposes of the participants. So in this second instance, we have the Serafín García Armas versus the Bolivian Republic of Venezuela. We have also Domingo García Armas, Manuel García Armas versus also the Republic of Venezuela. And lastly, Enrique Hemsen versus the Republic of Venezuela. These three cases were decided in a different way. I believe that maybe we can talk upon those cases later on in the discussion. But since my time is already lapsed, and as you can see, this is neither an easy nor a settled issue, I'm very grateful right now to hand over the microphone to the real experts on this topic. And thank you, Mallory.
Thank you so much, Maria Lucia. I love that you called this a gray area, because I think that's exactly what this is. In international investment arbitration, one of the basic ideas is that the dispute should be international. that there should be diversity of nationality between the two parties. And in many cases, there's a binary question. Is someone foreign? Are they a foreign national? Yes or no? They're either foreign or domestic. But dual nationals are simultaneously foreign and domestic. And that's why things get a bit tricky in this context. And as Maria Lucia was explaining, sometimes there are treaties that explicitly discuss what you would do in the situation of a dual national, but sometimes there's no mention of this at all. So I want to turn to Maria Eugenia now. What do you do when you see one of those treaties? What's the starting presumption? How do you interpret the treaty?
Well, thank you so much for organizers and panelists. Well, actually, Maria Lucia gave us I may try to not to repeat what she said, but it is important to say that the first main source that we have to look at is the applicable treaty, because the treaty is the lex specialis, is a special law that not only council but arbitral tribunals should look at. And I may say that there is three main types of treaties: those that expressly exclude dual nationals, those that impose requirements on dual nationals, and those that remain silent. In the case of those that exclude, expressly exclude dual nationals, we may say that there are a lot. Venezuela and Iran VAT, the Canada and Venezuela VAT, the Italian Venezuela, although it's not enforced, Romania and Canada, Switzerland and Egypt, Germany and Iran. So it is good to say that states are well aware that they are free when they negotiate and discuss the terms of the treaty. So they are then we're gonna discuss this further, but it is relevant to bear in mind that it is something very common among states that exclusion of dual nationals have been done expressly. On the other hand, we found that certain type of treaties impose certain type of conditions, like the dominant and effective nationality requirement, or domicile or residency conditions. As Maria Lucia said, we found Article 10 of the CAFTA and Dominican Republic Treaty, also Article 8.1 of the European Union and Canada Comprehensive Economic and Trade Agreement. Those provisions are clear enough to understand that dual nationals are protected under a treaty unless they can prove that the dominant and effective nationality is included. So this is a type of treaties that can be also found. In the case of the domicile and residency conditions, we found the Germany and Chile VAT, the Germany and Costa Rica, and also the Venezuela and Ecuador VAT. However, the main issue remains when the treaties are silent, and a question arises on that matter, because it is not easy, or for at first sight, it is probably not easy to find a single answer. However, in order to give the audience how this issue has been treated, we have to look at how arbitral tribunal have approached this issue. So we find a criterion based upon that, although no express excluded, dual nationals are considered to be included. And in this case, we may cite Serafín Garcia and Karina Garcia. Serafín Garcia and Karina Garcia wrote a claim against Venezuela under the Spain and Venezuela BIT, and the tribunal was clear enough when rendered its decision by holding that the Venezuela and Spain BIT fails to regulate the status of dual nationals and didn't impose any limitation on them. So before this case, we found Picas versus Chile in the decision rendered in 2008. And in that case, the tribunal had a similar criterion of the Serafin and Karina Garcia case. Then we have the case of arbitral tribunals that also found that if not expressly excluded and the treaty is silent, the tribunal have considered that dual national should not be entitled to protection under the BIT. And this is the case of Manuel Garcia Armas versus Venezuela, or against Venezuela. Manuel Garcia was or is the brother of Serafin Garcia. It is a case that in which the arbitral tribunal rendered a decision holding a criterion against the criterion held by the Serafin and Karina Garcia tribunal. So in that case, the tribunal said something like, if ICSID is included among the four listed in the dispute settlement clause, then dual nationals are not entitled to protection under the BIT. So these two cases are important to bear in mind because are practically, not practically, but they hold different criteria. So as I said before, there's not a straightforward answer in this question. And finally, if I may, my comment on the issue is that each case requires a particular analysis, that BITs should be interpreted in accordance with the ordinary meaning of its terms. I may say that I'm inclined to say that if not expressly excluded from the BIT, then dual nationals should be entitled to get protection from BITs. This is a criterion that have been not only followed by arbitral tribunals, but also by scholars such as Zachary Douglas. Arbitral tribunals are not entitled to rewrite BITs. This is a criterion followed by Yugos and Russia. And dual nationals are entitled to be in arbitration cases before arbitral tribunals under, for instance, before ad hoc tribunals under UNCITRAL rules. This is again the case that Garcia and Karina Garcia. And a particular comment I would like to raise here is that if states are no longer satisfied with the condition they discuss and negotiate, they may either withdraw from the treaty, not renew the treaty, or amend the treaty. These have been the case, or is the case of, for instance, Indonesia, also Venezuela. Venezuela withdrew from the ICSID Convention. It didn't renew the Netherlands and Venezuela BIT. So it is something that has been around, and this is, I believe, should be the way to treat this type of cases. If the purpose of having a BIT is attracting foreign investment, they are going to lose the investor's confidence. It's changing the terms of a treaty on a case-by-case basis instead of having a formal policy or having a formal investment policy. So it has been done by other cases, as I said before, by Indonesia, for instance. So these are my comments, and hopefully I may respond your question, Mallory.
Thank you so much, Maria Eugenia. Maria Baiju, I want to pose a similar question to you. What do you do if the treaty is silent? What's the starting presumption? Is there one? Can you generalize in that way? And if you can, is the situation that dual nationals presumptively are not entitled to the protections of an investment treaty, or that they are entitled to it? What do you think?
So I will, Baiju, if you don't mind, if it's okay, I'll go first. But before I go first, I'd like to, Mallory, thank you very much for moderating the panel, and to Xtrategy for inviting me in the panel. This is a great honor for me for being here, not just because Mallory, you and I go back quite a bit at Georgetown when you were being my professor, and Baiju has been one of my mentors, and it's a pleasure to be in this panel with you. So this issue is really interesting, because whether there is a presumption or not depends on the way I think that you approach the treaty analysis in that particular case, right? So since we're concentrating on treaties where the language is not there, right? Where the language of the requirement for nationality is perhaps only that it be a national of a state other than the host state, but is silent on whether there is that dual nationality. So then we can look maybe at the object and purpose of the treaty, but here too, it's not as clear cut as one would want it to be, I think, because you have, as part of the purpose and object of most of these bilateral investment treaties or investment chapters, you have the enticement of investment, of foreign investment, without necessarily discrimination from where those investments are coming from. But then we have the other object of the treaty, which is the foreign investor part. So I think in terms of the presumption, one has to look at the context in which the treaty was written, when it was written, what the parties may have intended. And I find it interesting that more and more what we see is the non-disputing parties coming in with their views, right? The parties, for example, we just saw it in the NAFTA case, where both Canada and the United States have come forward stating that even though the treaty does not stipulate, and even though the rules do not stipulate anything about dual nationals, that they do agree that there needs to be an analysis with respect to the dominant and effective test in order to ascertain what that nationality of that investor is. Baiju, I don't know what your thoughts are on this.
Hi, everyone, and also thank you to the organizers for the invitation. I think there's no right or wrong answer in the sense of this calls to mind to me the perennial fight in investor-state arbitration between what I think is the plain language of some of these treaties and the spirit of what the system is meant to accomplish. You had it, I think, in Tokyo's Tokeles, and you see Prosper Wilde's dissent. You had it in Wagi-Siag in Egypt, and you look at Orego Vicuña's dissent. And the idea is, how do we make sure that this system is serving its purpose for international foreign direct investment and not domestic investment? I guess one can only look at these cases with your own legal background hat on. And so I approach this as an English lawyer as well as a US lawyer. And you have to start, of course, with the VCLT, and you're looking at ordinary meaning. In the cases that Maria mentioned, the two cases against Venezuela, which by and large interpreted the treaty differently in the absence of any prohibition of dual nationality. The ordinary meaning of those words were, I think, quite simple, which is that it's not forbidden and therefore permitted, right? That's a classic common law view. But I also think it's pertinent to treaties in the sense that if you think about it, and Maria Isabel, you talked about intention of the parties, which I agree with, although of course the words are the best evidence of the intention of the parties. But if you think about it, in 1965, the original signatories to the Washington Convention were very clear that dual nationality was not permitted in, right? So back in the 60s, people understood that if you don't want dual nationals to bring claims, say it in the treaty. And they did it in the 60s. And then when various parties have acceded to that convention since, they've understood that that's there. In newer iterations, Mallory, your case in Valentine under the ARCAFTA, or in the new, I call it the new NAFTA because I absolutely despise that acronym and I can't say it. But you know, you have this dominant effective nationality test. So in other words, and I hate to again have this English common law hat on, if you, the party, as the state, want to ban dual nationals from bringing a case, say so. And it's as simple as that. And if you don't say it, then the ordinary meaning means that you didn't mean for it to be excluded. Where, and I have two difficulties with the cases, I think it was Serafin, I think, which was the one that said, I confused the two.
Serafin allows double nationals, and then the
Manuel, fine, thank you.
His brother is the country.
Thank you, Maria. So Manuel, where I have difficulty with that line, that avenue, and I'm not necessarily saying they're wrong, but where I have some difficulty is twofold. I think one, depending on how one looks at the Article 31 of the VCLT, you can put equal weight on ordinary meaning, context, object and purpose, and good faith, and see them as four equally heavy categories in which one must put equal buckets. I personally don't see that the Vienna Convention should be interpreted like that. Rather, I think ordinary meaning is the predominant force, of which object and purpose and context are ballast, and good faith is the overarching umbrella. And if one does that, what one sees in decisions that I would question for teacher interpretation is too much emphasis on object and purpose, right? And I think where ordinary meaning is very clear, I think trying to stick in a different interpretation to object and purpose, I think is very difficult. The second part I have some difficulty with is putting in this dominant effective nationality test. And I think it's doubly difficult. One, because obviously we know that comes from diplomatic protection, general international law, and where a treaty doesn't invite that kind of international law within its scope. In fact, by being silent on it, one can say it's actually excluded. How do you actually even get it in, right, in the first place? And second, and this is a bit of a personal point, I take some umbrage as a dual national, Maria Isabel, I wonder if you do too, to the idea that I am any less, I'm a British national, I married a wonderful American lady, I have an American passport as a result of that marriage. Mallory, you I think were born a US national, right? I am not any less a US national than you, right? And I got my nationality in 2014. So the idea that someone is going to say to me, well, yeah, but Baiju, you live in London and you have a British accent and you know, you read British newspapers and you like football, and by that, well, I say football and I mean English football and not soccer, that someone's going to tell me, well, you're more British than I am American. I just find that, I mean, for diplomatic protection, maybe that's something of interest in international law. But the idea to tell me that when I invest, I am more British than I am American, I find that kind of, you know, personally a little bit strange. Now, I hate to use a personal viewpoint to say, well, the test is wrong on international law, but I just find that it's somehow shoehorning it into treaties that are silent and a test that that says, well, you're not quite American enough. I find that difficult, particularly when, taking it back to the contract interpretation point, the state should know that there are people like me that exist. There are dual nationals, that dual nationals will invest, that the treaty is silent when it could have been explicit. And as a result, as an American, I'm going to invest. The only time I would say that it's an obvious point where dual nationality shouldn't be something available to me is if I could only have invested because of the fact I have my domestic nationality, right? There are some lands or something that I got a check the box because I was a domestic national. But other than that, I think the states are opening themselves out by the language in their treaty. But as I said, I don't take particular issue with the tribunals that have determined this the other way, but I have difficulty seeing it myself.
Baiju, you mentioned the test, dominant and effective nationality. This is a phrase that has been around for many, many decades, but in the investor state context, it hasn't really been defined until recently. So what is the dominant and effective nationality test? How does it work in practice? What are you looking into? And Maria Isabel, let's start with you. I know you wanted to talk about this topic.
Thank you. Just a little aside on the personal with the dual nationality is very interesting, because as I was thinking more and more about today, that came to mind, because I was born in Venezuela, but I chose to be an American, but I did not choose to leave the other nationality, right? And so if one asks me, even just in regular life, what do you associate more with? Are you Venezuelan or American? And it's very difficult, right? And sometimes it has to do with the context of what you're doing, but at the end of the day, you don't have that difference, even if I may have never voted in Venezuela, or some of these things that you look at in terms of the dominant test, right? So it is a little bit of a difficult concept to grasp. I understand it from the diplomatic context, extrapolating it to the investor state arbitration context makes less sense to me unless a treaty actually has explicitly brought it in, because at that point, obviously, the parties have agreed to it, and then that is what it is. But to ascribe that to a treaty that doesn't have explicitly that requirement seems to be a bit of a potential stretch of the interpretation of that treaty in particular. With respect to what the dominant and effective test is, there are some things that were important in the diplomatic context that are not nearly as important, it seems, to tribunals in the investor state context. For example, the issue of where you were born, right? So where you were born does not seem as important to a tribunal, not only because of the issue of timing, which we can talk about later, of when you should have the dominant and effective nationality, but also because many things happen in your life after you were born, right? Yet from a personal perspective, where you're born defines a lot for most of us, where you feel your dominant and effective nationality is. And Maria Lucia, you touched upon the Carrizosa Tribunal, and I thought that was a very interesting way in which the tribunal was trying to ascertain what that dominant test should be, where it specifically where it talks about whether you should look at the objective criteria or you should look at the subjective criteria based on what that investor or that claimant feels objectively as he or she relates to more with respect to that. And what that tribunal ended up siding with is that the subjective criteria is not what the tribunal should look at, but rather the objective criteria. And the objective criteria includes the Valentine's case actually provides a easy sort of 4 elements that you look at. And I'm looking at the case, and they the evidence that they, not the evidence, but the elements that it talks about, and you know this case better than I do, Mallory, is the state of habitual residence, the circumstances in which the second nationality was acquired, the individual's personal attachment to a particular country, and the center of the person's economic, social, and family life. The first three, I feel, are pretty easy to determine. The fourth one, the center of a person's economic, social, and family life, is very difficult. And I think it's very difficult in particular in this day and age, because most people who are dual nationals generally have homes or property in different countries, in both countries in which they're nationals in general. They have family in both. In most cases, you travel and kind of live in between both of those places. So it's interesting to see, what does that mean? Is it 51% more in one country than the other? Is it 75% more? Where is that line? And I think that even the tribunal may want to make this as objective as possible, it eventually becomes a very subjective line that moves depending on a holistic view of all of these aspects.
What is an effective nationality? And when we're considering these issues of dual nationality, do you need to bear in mind that there may be different types of dual nationals? So you may have someone who is born in one country and moves to another country and decides to naturalize and acquire the second nationality. You could have someone who is born with two nationalities. So Baiju, as you mentioned, I was born in the United States. My mother was born in Pakistan, and I don't know how the rules on nationality work. So it's possible that I am a dual national, but there are different types of dual national. Does that come into the analysis? Does it go under the effectiveness prong? What's that side of the equation? Because we hear a lot about dominant nationality or predominant nationality in the cases, but not so much effectiveness. When does that come up?
I would put 2 points in that, Mallory. One, I think Maria Isabel hits the nail on the head, which is, at the end of the day, you weigh up the evidence, and there's going to be, at some stage, quite a subjective view. And the effectiveness, I think, I'm sort of, I'm not basing this on any case, but what struck me is in the Ballantyne cases is Marnie Cheek's dissent on timing. And I wonder whether there is some question of effectiveness, in other words, effective at a particular time. Because if you take the position that my dominant nationality is, at the time I'm born, clearly probably the place I'm born, although I would question the criteria of evidence at the time where you actually have no choice in that matter, right? I wonder whether adult life is more relevant than your childhood, for the simple purpose that really it's not your choice. It's rather unfair to say, well, you're not dominant effective national of one state when really it's your parents' choice. So let's put that aside and say, well, we're looking at your adult life and your adult choices. Then the question is, well, is it simply you take a point in time, right? So in Ballantyne, they said, well, we're going to choose a crux juxtaposition of the time that you made the investment. Let's do the analysis at this particular time. Now, what I understood the dissenting arbitrator to be doing was saying, okay, well, let's weigh it up. Right? Let's weigh it up from the beginning, from the time you were born to now. And it's very clear that if you do the weighing up of the whole time period, you're American, or they were American. Whereas it seems that the majority, and this potentially goes to the effectiveness point, is no, what was it at that particular time? In other words, if you weighed it up then, what were you doing at that time? At that time, you were here, you were doing this, so in some sense for me, the labels of dominant and effective probably go to not just what is more than the other, but when the question is of that test.
So I want to move a little bit away from the Valentine case because I was counsel in that one and can't comment on it. But I do want to talk a bit about evidence, as you mentioned, Baiju. What evidence is used in these cases? Is it easy to find? Is it difficult to find? My mother the other day was trying to find her original birth certificate and it took her forever and she was worried about going through a lengthy process to try to obtain it. Does that come up in these cases? What's the evidence side of things?
Look, I think my own view is everything is fair game, right, to start with. I think what I think is most interesting, so when I say everything is fair game, I mean, you know, and really it's the discovery point, right? You win or lose this on discovery, really. As a respondent state, arguably, right? So on the one hand, it depends. On the one hand, you could say, well, the claimant must prove its case and it has to prove the effective and dominant nationality and the state has to do nothing. And if the claimant can't meet its burden of persuasion, production, however you want to say it, but the burden of proof in general, then the state doesn't actually have to do anything. But of course, if you were the state and if I were representing the state, then I would be asking for, okay, you say your dominant effective nationality is X, show me this, show me this, show me this, show me this. And of course, the absence of those documents will tell me that that is not your dominant effective nationality. And I would also ask with regard to your domestic nationality, show me this, show me this, show me this, show me this, to show the tribunal, look at all the evidence on this side and look at the absence of evidence on this side. So in a sense, I think it really is on the claimant if the tribunal are going to take this dominant effective nationality test as its lodestar to produce the evidence that it needs to produce. Where I think, and then ultimately, I think it's for the tribunal to put weight on something that, and as Maria Isabel says, it can be entirely subjective, right? Where you have bank accounts, where you have homes, where you pay taxes, where your children are, where you raise your children, etc., etc. Where I think is the most interesting for me is the question of passports and official documents, because I think prima facie those should get absolute official status. Okay, they are what they are. They say what they say. I think the two interesting parts are one where the state comes in and says yay or nay, right? It has a view, and that view may be different from the claimant. And I always find that interesting. Or the state comes in and says, yes, as far as I'm concerned, this person is absolutely a valid national of my state. But that local law or the local law of the home state, the host state says that, well, maybe you could not have acquired that other nationality, right, without removing first this nationality, or you lost this nationality, or, right, you in other words, there were steps you had to have revoked in order to gain the other one. And I think it's that interplay between the two states, because we all consider ourselves maybe plainly dual nationals because we hold two passports. But actually, under law, it may actually very well be that there is a disconnaissance between, right, the legal position of having those two nationalities. But I think for me, Mallory, that this is won and lost in discovery. But if I'm representing the claimant, I'm coming up with everything. I'm coming up with my Facebook pages, my kids' drawings of their homes. You know, I don't care. In my witness statement, I'm talking about my beautiful upbringing, my mother's cooking. You know, you just have to paint the picture and tell and show the tribunal that, look, I am this. Or of course, if I've shifted nationality to another place, to say, well, look, I hated the horrible regime, the government, and I wanted to go to the West or wherever. And these are my principles, and I love the idea. And here's me in my T-shirt with the flag. And you know, I'm trying to paint the picture for the tribunal. So ultimately, they see, you know, and it's important to see me as that other nationality, and then the evidence will sort of lead the way in terms of the portrait that I'm painting for them.
Well, and when you go into all of those things, I can see why, as a dual national, it would bother you with this idea of the dominant nationality. I guess the way I think of it sometimes is a question of, is this person sufficiently foreign to the country that they're trying to sue to enable the dispute to be considered an international dispute? Not so much a personal judgment of you. Are you more X? Are you more Y? But just
so the question I would ask you, and maybe you can answer this, but I have a passport. What's not foreign about that? Right. So I think that's the first question, right? The fact what makes this person foreign is the passport. And so I think that, for me, that's the starting point. And then you say, then you ask yourself, what do the states agree with regard to people like me who have two passports?
I think that's the key. You have two passports. I have this one passport, it means X. I have this other passport, it means the exact opposite. What do you do? How do you decide when you are in this sort of Schrodinger situation where you are simultaneously two different things, or simultaneously two qualities that for many people are binary and separate, but you are both of them at the same time?
I just want to add something that it is, if the treaty says that if the treaty doesn't exclude the dual nationals, and then the definition of investor is that an investor is considered to be a national of X country based upon what the local says of that country request, then we are asking claimants to present the burden of proof to a claimant to bring proof that are not expressly required by treaties. It is unfair because the treaty doesn't request so. The treaty requests only that the national is a national of X country based upon whatever it is required by its law. So if law says that you are a national of X because the law of that country said so, this is the problem I found in this type of cases, because always a state will say, yes, but you have to prove that you have a genuine link. A genuine link. Again, it's something that is imported from a diplomatic protection, but it's not something that is really in the investment arbitration field.
So I promised the audience that we would open up the floor to them for questions. While we were waiting for some of those to come in, I wanted to see if Maria Lucia, do you have any questions that you would like to pose to the panelists to start off the discussion?
Yes, thank you, Mallory. Yes, I have a question. And it's about the relevance to rely on the preamble as a means to interpretation in order to define whether a national is covered by the agreement or not. From my understanding, of course, in order to interpret a treaty in light of its object and purpose, which is usually stated in the preamble, we should take into account, and I'm not saying that this is my position, but it just came into my mind, that investment treaties are executed between parties to protect foreign investment, right? And also, it should be seen by some like an exceptional concession of sovereignty by an state. So why should we, at the moment of interpret the bilateral investment treaty, do it in a wider manner rather than a stricter manner if it's an exceptional concession of a state of its sovereignty shouldn't be interpreted strictly rather than in a wider manner? So that's what it came into my mind, but I don't know if our panelists have any thoughts about it.
I can take this one. I would say, look, I think the sovereignty point is a fair one, because absolutely, I think BITs are I guess, a devolution of sovereignty, right? You are, otherwise the investor is required to go to your host, to your national courts. And by signing this treaty, you are giving up some sovereignty, surrendering some sovereignty to give them some rights. And the question is, well, why should you interpret it? Why shouldn't you interpret it strictly? I think it goes, and then I'll come on to your preamble point in a minute. I think it goes to my point that if you wanted to exclude dual nationals, you would have, right? So I don't think I'm interpreting it narrowly. I'm interpreting it by the ordinary terms. And if you haven't put that in there explicitly, then I don't think I'm interpreting it narrowly. I'm interpreting it by the terms that you used. So in other words, I would question the concept of narrow or broadly, and just say, well, it's ordinary meaning per the VCLT. As to the preamble, I would say two things. One, again, I think obviously the preamble is very important in object and purpose. But then the question is, well, is object and purpose of equal value to ordinary meaning? And I don't read Article 31 in that way. And really the question is, you're looking at more. I find that when tribunals go to object and purpose, they're looking more to the spirit of the system necessarily than the ordinary words that have been used. But I have to say I have sympathy with arbitrators who want to make the system closer to what it's meant to be, right? Because I think that's what we should be doing. I think that's what we should be striving for. Is we want for the whole idea, if you look at back in the 60s and the history of the convention, is the idea is, of course, we want foreign direct investments because it's a good. And if we allow in domestic investment just because someone has a foreign passport, then yeah, that's troubling. But at the same time, you have to say that states, when they signed this treaty, had probably already signed the ICSID Convention and knew how to exclude dual citizens. And if they didn't, and knowing that dual citizens would make investments, you have to question the state, really, right? Rather than sort of use what you could argue is judicial intervention to fix what the state didn't do for itself. That's where I have a little bit of an issue.
Does it matter to anyone when the treaties were signed, if they are, first generation bilateral investment treaties, if the respondent state maybe is facing now the first investor state case? Maria Isabel, you look like you want to jump in.
Oh, no, because this is very interesting in terms of the treaty interpretation. And I think, again, I also get confused, basically like the same with Serafin and Manuel de Garcia Armas cases. But part of what the tribunals were doing in the interpretation, they were saying, look, ICSID was the primary option, right? ICSID arbitration. ICSID excludes dual nationals. Therefore, when you go to the secondary arbitration, right, option, whether it's UNCITRAL or something else, then does that mean that we can imply that the states agreed to exclude dual nationalities because the primary mode of arbitration was ICSID arbitration, and that excludes it? It is an interesting read. I'm not sure where I stand in, but I feel like that is a very sort of interpreting broadly what what a state may be saying by that, because there's all kinds of other things that are in the ICSID Convention that are not in UNCITRAL rules, which we're not saying they're imported by the very fact that the primary form of arbitration is ICSID. But that is one way I feel in which tribunals have tried to sort of come to terms with this idea of the silence in the treaty. But then the other one that I find interesting, and this is just sort of to pose it for all of us to think about and discuss, is you were just asking about the timing. Is it the first treaty or not the first treaty? But we also see states in which some treaties don't exclude it, and in other treaties with other countries, they do exclude it. So if we follow that interpretation of the Garcia Armas tribunals, then by that same interpretation, we should say, well, if you were able to exclude it explicitly in some of your treaties, and you did in this one, then this one must mean that you're not wanting to exclude it, right?
I think the idea of since 1965, everyone has known that you can exclude dual nationals argument is an interesting one. But I would also be interested to see what different states around the world were saying about dual nationals at the time. In some places, if you acquired a second nationality, you automatically lost the first nationality. And I forget when exactly in the United States the Supreme Court said that that was unconstitutional, but it was more recently than I would have thought it was. So that might be another interesting angle on timing and context. We're getting some questions from the audience. One was about terminology. And the question was whether, when we're speaking of nationality, if that is the same thing as citizenship, and to the extent that different terms are used in different treaties, what we should make of that.
I mean, the only thing I could say, it's actually a great question. And it's absolutely correct that in legal terms, I think it's different in the sense that I think citizenship is a legal conferral of documentation, and nationality is more underlying factual reality. And they are absolutely used interchangeably. What I can't answer, I'm afraid, Bavik, is whether that's right or wrong. But he's right that there is a legal difference between the two. Yeah, I guess the point is that citizenship is something you either have or you don't. Nationality maybe is more effective and dominant, right? Because effective and dominant citizenship doesn't make sense because you either have a piece of paper that says you are or you're not. And I wonder whether then the question is the word national goes to nationality and therefore allows a view of dominant effective nationality and doesn't say citizen, which is more the legal test. And therefore maybe Bavik has hit, on a thread of a definition of the word that actually allows the dominant effective nationality test to come in, even if the treaty is silent. I think it's a fair question to explore, and maybe Bavik or someone else does an article in that.
We only have a few more minutes before we're going to turn to the breakout sessions and some networking. Would anyone like to make any final comments?
Well, it is like a side comment when Maria Isabel was talking about the settlement clause, that it has when that clauses is meant for at least in the case of Venezuela, it is common to see that the first option is ICSID, then the additional facility, and if these two options are not available, then you can resort to the ad hoc tribunal with UNCITRAL rules. So this is important, and it was important in the Manuel Garcia case, because actually it was a surprise to me that the interpretation of the arbitral tribunal was because ICSID was listed there then automatically the dual national were excluded. When in my opinion, it was the other way around. It was like a hierarchy of fora, and then the dual national should be entitled to resort to an ad hoc tribunal under UNCITRAL rules. Just for the records.
Marie Isabel, I'll give you the last word, Marie Isabel. Maybe I'll go, and then I'll give you the last word. The honor and privilege of the last word. I would only say this, Mallory, which is that I think the system should be a little more sensitive and careful with dual nationality of individuals than it need be with corporate nationality. Because it's not personal to the individual, right? I think one takes or lose. I remember swearing allegiance to the United States, and all I could think of my brain was the Queen, right? I was like, oh, poor Queen, because I had to sort of say I wouldn't swear allegiance to her, and in my heart I kind of did. But it's very personal, right? It's not like a corporate nationality that you can go to Cyprus and switch tomorrow. And so the idea that people are interchanging nationalities and this and that, and one's dominant and effective, we're talking about human beings and their lives. And I think the system and arbitrators should be a little sensitive to the fact that, unlike potential abuse of process and treaty shopping through nationality of corporations, I think there's less of that with nationals, and therefore I think there's a difference between the two, and I don't think we should conflate them.
Maria Isabel.
Thank you. Thanks, Baiju. So I completely agree with that view as well. What I wanted to say rather is maybe perhaps do an observation in a question that we could potentially comment or explore in our individual groups when we separate. But when we were talking about evidence and burden of proof, it's very interesting, right? Because obviously the claimant, whoever that claimant is, has the initial burden of proving what their dominant nationality would be under this rubric. But what is very difficult to do is to show what is not your nationality, right? How do I say, well, even though I'm from Venezuela, Venezuela is not my dominant nationality, right? So I think at some point, maybe the burden shifts, right? After the claimant has actually met some sort of prima facie burden of what they consider to be their dominant nationality, even though there are other aspects that may or may not show that there's some contact or some relevance with the other country. Being the host state, the ones that potentially has all of this evidence, right? Because nationality has a lot to do with the legal interaction with the other country, whether it is the host state at that point that has then the respondent state that has the burden to prove, if not just to poke holes on the claimant's case, but to actually prove that no, the host state, the dominant person nationality is that of the host state. So that's just a question I want to leave out there for us to consider and perhaps chat about.
On that note, and being perfectly on time, I want to thank all of the panelists, including our presenter, for a fantastic discussion. Jose Antonio, we are in your hands now for the breakout sessions. Wonderful.
Well, I am extremely grateful for this masterclass on dual nationality and dominant and effective nationality. I know that many of these issues are now being addressed by ICSID and other investor state arbitration tribunals. This is a quintessential topic for our update, because for many years we did not see cases on dual nationality, and in the last 5 years we've seen quite a number of them, and the world is waking up to them. And as you can see, the issues with very similar treaties and fact patterns have ended in different results. So I would really like to thank, in the order that you appear on my screen, Maria Isabel and Maria Eugenia and Baiju, Maria Lucia, and of course, our stellar moderator, Mallory. I think that you did a fantastic job, and just staying safe, one, and two, putting the questions out there for the panelists to address them. Now, I would like to leave you with a question. Perhaps whomever wants to take it in the breakout rooms, is whether the criteria of dominant and effective nationality is really an out of date criteria. It was created in last century, at the beginning of last century, at times when if you travel to a new place and you started living there, eventually you could say, well, that's where you live, and you become effectively and dominantly from that place. Nowadays, as many of us or many people have it, they could eventually be, or someone could say that they could be dominantly and effectively from both places. But that's a question that's food for thought, as to the dominant and effective nationality is a criteria for our times or not. Having said that, we will give place for the breakout rooms. Thank you so much for being here and for bringing diversity of ideas and thoughts and arguments to our World Arbitration Update. Let's go into the breakout rooms.